Team Karen Reed has officially filed their appeal to overturn the Honorable Judge Beverly Cannoni's ruling she made to keep the second-degree unaliving charge intact. But that is not the best part, folks. In fact, the best part and what's driving everybody who is anti Karen Reed nuts is that they quoted Turtle Boy. One of his articles was cited in this appeal saying, quote, Aiden Carney can't cover up part 397. Karen Reed, juror, says they switched on manslaughter verdict, confirms unaliving acquittal, says jurors couldn't ask Judge Cannoni questions about two verdicts, September 6, 2024. We got the article. We got the SJC appeal documents. All this and more in today's video. Hello, and welcome to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, we are just people. People who have opinions about all things going on in the true crime community, including this appeal that was filed by Team Karen Reed yesterday, asking the SJC, as Ted Daniel of Boston 25 News reports, to overturn the Honorable Judge Beverly Cajones ruling to keep her second-degree unaliving charge intact. Remember, we did that whole stream of Marty Weinberg, Karen Reed's third defense attorney that she had hired to help with this motion to dismiss, which Judge Beverly Cajones did dismiss or denied in her own right, and now it's going through the appeals process, which is why, she already anticipated that there was going to be somebody, whether it was going to be the Commonwealth or the defense, somebody was going to want to appeal, which is why she allotted as much time as she did to set the trial date for January 2025, which is wild. But I also low-key, and I said this in my last video, I think it could be interesting because just imagine if there is a retrial, right? And it's snowing and they have to do the viewing again, which they should, go back to 34 Fairview. It's a new set of jurors, right? But this new set of jurors goes to 34 Fairview in the snow. Like, imagine, oh my God, that would be absolutely brilliant, because then I feel like you'd be able to visually see what those conditions were like. And then if you could just line it up or time it out properly, where the viewing is after the testimony with Nick Garino, and if, God forbid, they call Trooper Paul again, I feel like all the pieces would really start to fall in place. But I don't know how they would have control over that, let alone over the weather. But in my mind, that would be amazing if there is going to be a Reed trial, or a Reed trial, as we say here on this channel. So he goes on to say the defense has argued that charge should be dropped because jurors in her first trial reported they agreed, which we're going to read in 1 second, to find her not guilty of that charge before a mistrial was declared. Reed's lawyers have said that violates her double jeopardy protections, which is exactly what they outline brilliantly in this appeal. So this is the Turtle Boy article that they are referencing. And I don't know if I haven't run through, admittedly, the entire document. It's about 37 pages or so long. But this is the one that jumped out to me, and his girlfriend, Meredith, who is brilliant in her own right, she had tweeted and called out too that, hey, Turtle Boy made it into this document. He was cited. And I think with just all the other stuff that's going on as well too, and people constantly, mainstream media, referencing him as a blogger, and almost like as to demean him and the work that he's done and the lack thereof of work that they have done in terms of investigating. Ted Daniel has been pretty awesome throughout this coverage, but most mainstream media that is covering this story hasn't gone deep. Nobody has gone as deep as Turtle Boy. So, and he got the exclusive. So this is the article. Canton cover up part 397. Karen Reed juror says they switched on manslaughter verdict, which we read. Confirms unaliving acquittal, says jurors couldn't ask Judge Cajones question about two verdicts. So I'm going to read through not the whole article. You can go sign up for TB Daily News if you want to get it ad free, or you can also read it for free, but there's tons of ads on there too. Go support. He's awesome. But I wanted to point out the specific parts that they were quoting. So this was the big thing, right? Because essentially what the defense was trying to argue, and I can link that video back where they have that hearing about the motion to dismiss. It's about, I think, an hour and a half to 2 hours or so. And essentially the defense just wants to know one thing and one thing only, which you can accomplish pretty much in one or two questions tops, is did you vote not guilty on counts 1 and 3? That's it. We don't need to know what happened in the jury deliberation rooms. We don't need you to expand any further on that. Just yes or no, and that's it. That is what they wanted. That was what their motion to dismiss essentially was all about. But oh my god, did I just scroll away from it? Oh yeah, here it is. I was like, did I just scroll past this? Did the jury believe that John was bit by a dog because there were two doctors who said John was bitten by a dog? The jury believed, this is from the juror, there was reasonable doubt. That's why there were 6 people who had reasonable doubt. It was very clear, and this is what they cite in the appeal doc. It was very clear on charge 1 and 3. Unaliving was decided on day 1. Now, the second juror that he just wrapped up interviewing, I don't know if there's going to be a part 3 on that. I mean, I feel like at this point he's asked probably as many questions as you possibly could ask for one person. It'd be interesting to get the perspective from somebody who voted guilty just to see why and have a different perspective of their understanding. She did not have an intent to unalive. So that was what they were essentially pulling and citing from that specific article, which is really, really interesting. So I'm looking forward to see how that continues to unfold. I will copy and post the link. I know I say this all the time. Sometimes my brain, I'm editing these things super late at night as I'm in bed, literally falling asleep, and I forget to do things, but I will make sure I share a link to this article so you can read it and sign up and support Turtle Boy as well if you so choose. But before we get into the SJC appeal doc, right, which is a little bit of a monster read, but we're going to get through as much as possible. How does the Norfolk County DA's office respond? I mean, pretty much with this blanket statement, I'm sure they're going to develop their response over the next couple of days, potentially even weeks. I'm not sure exactly how much leeway time there was last time or how much time in between the affidavits that seemingly felt like they were dropping every single day like a new mixtape. Um, the Commonwealth felt a little delayed in their response, but this is just their blanket statement that they're making. So, the Norfolk DA's response to Karen's appeal is the Norfolk DA's office is aware that counsel for the defendant filed a petition for relief pursuant to GLC 211, yada yada. As this is an open case, the Norfolk District Attorney's Office's position and statement will be filed with the SJC. So it seems like, I mean, they already did announce this. They are going to pursue the M2 charge, but who knows? I mean, also, all roads are pointing to just drop that charge. I get it. You're kind of stuck in this position that you put yourself in. You never needed to bring this to trial to begin with. But all that aside, we're in the position that we are now. The best thing you can do is drop the M2 charge and pursue, tighten your case up as much as you can, possibly, which I mean, at this point, what is there even to tighten up? Half of your all-star witnesses are under internal affairs investigation. The feds are also involved, but hey, whatever. All that aside, let bygones be bygones, and stick to the manslaughter charge. Stick to that because that was the one that you can seemingly convinced at least what, 8 jurors, or 2 or 3 of those ended up flipping at the end that were originally not guilty, because initially it was 6-6. So it's a mess, man. It's a freaking mess, but we all knew that. So let's go into this relief of pursuant, uh this petition for relief pursuant. Whoop, that's really large. And yeah, it's 37 pages. So we're gonna get through as much as possible. Let me just take a sip of water so I'm not coughing up a storm again, like in my last couple of videos. Okay, so Karen Reed petitioner, Commonwealth versus, right? Commonwealth of Massachusetts respondent. She has, if you'll notice, another attorney that's been added to her team here. A lot of people are like mad about that. Why does Karen Reed have a fourth attorney? Because she's Karen Reed and you're stuck with Lunchbox Lollipop Lally. Like, I don't know what to tell you guys. I don't know what to tell you, but I imagine he's probably being tapped to help with probably a lot of the court filings, etc. I looked this guy up actually just to kind of show you a little bit more of who he is. There's not like a whole lot of info on him, at least on his website, but this is his website: client focused Boston defense attorney to protect your rights. This guy over here, Michael Pabian, or I'm assuming it's Pabian, uses high level legal writing. Yeah, so he's probably the guy that they're tapping to do all the. He probably wrote this thing under the guise and guidance of the rest of her team as well too. So this seems like why he was tapped in for help. Is he going to be part of the retrial? My assumption would be probably not. But again, like every time she retains a new attorney, everybody's like, I see Karen Reed's rich. Like, it's like, who cares? If she has money, she doesn't have money. Clearly, she's spending hundreds of thousands of dollars on her own defense. Yes, she's getting support from people who believe in her innocence, because that's what happens when people believe that somebody is going to get wrongfully convicted, is that they donate to causes they believe in. And guess what? They have a right to do that, just as you have a right to complain about it and whine about it on Twitter. But anyways, so she has a new attorney. Yeah, and like I said, my assumption would be he was probably used for the purpose of drafting this stuff up, and if it goes any further, obviously, he'll be there to assist with this further. So this is all the case law. I really like how he outlined this. If he was the one to draft this, table of authorities, like it's just very aesthetically pleasing, and you can look up all the case law as well too. I looked up some of it just to get a deeper understanding. It's a lot. It's dense, it's a lot, but let's dive in. Okay. And I'll link this as well in the description box. Now comes the defendant, Karen Reed, who is aggrieved by an August 23rd, 2024 memorandum of decision and order denying her motion to dismiss on double jeopardy grounds in Commonwealth versus Karen Reed. This is going to be, folks, the case of the ages, things that is going to be studied for the next 100 years in law school. I can bet your bottom dollar. The order, as it currently stands, will result in Miss Reed being retried on January 27th for the same 2 alleged crimes, including second-degree murder, that a second-degree unaliving, that a jury of her peers has already unanimously agreed the Commonwealth failed to prove beyond a reasonable doubt following trial. Because the jury reached a final unanimous decision to acquit Miss Reed on those charges, and because there was no manifest necessity to supporting the declaration of a mistrial with respect to charges on which the jury unanimously agreed, retrial on such counts would violate the double jeopardy protections of both the federal and state constitutions and the common law decisions of this court, enforcing the protections of double jeopardy. To sum up and dumb down, because sometimes it's like a lot of lawyery mumbo jumbo, but again, this is for the court, not for lay people like us to read and understand, but we do it because it's interesting and fascinating and we learn a lot. They are essentially saying that because the counts 1 and 3 charges were unanimously decided by the members of the jury, according to these articles, according to the affidavits, them directly contacting not only the defense but the Commonwealth as well too, which we have no idea when that actually happened or not, because those dates were so confusing in that motion, that their response to the affidavits that the defense filed. So yeah, essentially they're saying the jury unanimously decided that counts 1 and 3 were out, not count 2. That was the one that they were stuck on, which was the manslaughter charge, and therefore double jeopardy should apply. Or we should at least be able to inquire, which is the reason why they filed the motion to dismiss initially, and Judge Beverly Canoni denied it. Miss Reed seeks relief from this court through its discretionary superintendent's powers under GL chapter, I'm assuming 211. I have no idea. I'm not going to lie. Layperson doesn't know. This weird looking $3. In support of this petition, the defense has submitted a memorandum of law incorporated herein and has attached a record including the following documents. So these are all the things that they're including. And this is what people were like bugging out on Twitter last night. Full docket report, Norfolk County Superior Court indictment numbers, a transcript of the charge to the jury June 25th, 2024, transcript of jury trial pages. So this is the pages 114 to 136. Defendant's motion to amend the jury verdict slip with count 2 supporting affidavit filed June 26th, 137 to 45. Transcript. By the way, guys, you can get all this stuff too from Sleuthy Goosey as well. She has all the documents. So if you're looking for all this stuff to nerd out on and dig through, go give her a follow as well too on Twitter. Transcript of jury trial June 27. Transcript of jury trial. Defendant. So, and like these are specific pages too, which I'd be curious to like see in terms of transcripts. What if any? That would be interesting to read. And like testimony that you can go back and rewatch as well too. Defendant's motion to dismiss and supporting affidavits filed July 8th. Defendant's supplemental memorandum in support of her motion to dismiss and supporting affidavit. Commonwealth's opposition to defendant's post-trial motion to dismiss. Defendant's reply to the Commonwealth's opposition. Defendant's second supplemental memorandum in support of her motion to dismiss and supporting affidavit. Commonwealth's post-trial notice of disclosure. Defendant's third supplemental memorandum in support of her motion to dismiss. Transcript of non-evidentiary hearing on motion to dismiss. Memorandum of decision and order on defendant's motion to dismiss against August 23rd. Yada, yada. So, and like I said, people were bugging out about some of these things last night. Let me bring up a Joe Flipperhead. One second. Yeah, so there's this whole thing about the sidebar, um, because they mentioned, hey, later in the document, they mentioned, hey, there's a sidebar, and everybody was freaking out on Twitter about what it could possibly mean. Um, so Joe Flipper had pulled this up. Actually, let me set this up better. So the one that everybody is freaking out on is it's not in this actual thing here. The one thing that everybody is freaking out about or was freaking out about, and then we got clarification, was so the defense filed new motion to appeal. Interesting to note transcript of sealed sidebar from 524. Who testified that day? Brian Higgins. So everybody thought it had something to do with Higgins' testimony. Um, Spoiler alert, it did not. It had to do with something completely different, but let's play. So this was because it is interesting. May 24th sidebar, you had a formal interview with some folks prior to your testimony at a prior proceeding, the grand jury hearing that happened because of the federal investigation.
You had a formal interview with some folks prior to your testimony at a prior proceeding. You understand what I'm talking about?
I'm tracking.
Okay. At the formal interview, which is what I'm going to call that.
Okay.
The formal interview, you were asked about Brian Albert and his reputation, were you not? Yes or no?
Yes.
You indicated in that formal interview that even Chief Berkowitz was
Objection.
quote, a little afraid of Brian Albert.
All right, so that is the objection sustained. That's stricken. I'll see you at sidebar.
So, and I think this is interesting because if you recall, folks, in one of the affidavits, and even in some of these interviews as well, too, the jurors have expressed that they were a little intimidated by Brian Higgins on the last day of the trial, right? In closing arguments. But who was sitting there? That wasn't Brian Higgins who was sitting in the audience, who was sitting in the peanut gallery. It was Brian Albert. They got the two buff boys mixed up. So I think it's interesting. I mean, this was ultimately debunked in reading this motion because it's actually this appeal because it's actually explained why they're quoting it, citing it. But it is interesting because I could see that as being a tie into juror intimidation, right? Jurors literally feeling uncomfortable, as quoted in the affidavit, by the presence of Brian Albert sitting in the peanut gallery behind the O'Keefe family, which was directly across the room from where they were seated. So the point that Alan Jackson was going to make here before the objection went through and the question was ultimately stricken was that during the grand jury hearing, Senior Berkowitz, we talked about baby Berkowitz in yesterday's video, Senior, his Papa Berkowitz, had expressed he was intimidated by Brian Albert. So that's what he was trying to essentially elicit from Brian Higgins here is that, and I'll play the clip again, Berkowitz saying Brian Albert is intimidating. Which, I mean, we can all agree. I mean, he's a scary looking dude.
You had a formal interview with some folks prior to your testimony at a prior proceeding. You understand what I'm talking about?
I'm tracking.
Okay. At the formal interview, which is what I'm going to call that.
Okay.
The formal interview, you were asked about Brian Albert and his reputation, were you not? Yes or no?
Yes.
You indicated in that formal interview that even Chief Berkowitz was
Objection.
quote, a little afraid of Brian Albert.
All right, so that is the objection sustained. That's stricken. I'll see you at sidebar.
So again, this is why everybody thought that May 24th impounded transcript or sealed transcript request had to do with. So there's that. I might even do like a video just going through his entire like cross-examination again, because there's a lot of stuff in there that I think we could learn from. And um I think there's just so much more to his testimony and his role, I believe, Brian Higgins, in this big giant cover up. I don't know what part he played in it, but he did some shady stuff in the days and hours after John O'Keefe was found on the front lawn of 34 Fairview, which is the home that was formerly owned by the intimidator, Brian Albert. So, general superintendents of all courts of inferior jurisdiction to correct and prevent errors and abuses therein, if no other remedy is expressly provided, and it may issue yada yada yada. Okay. A criminal defendant who raises a double jeopardy claim of substantial merit is entitled to review of the claim before she or he is retired. Is and blank is the appropriate route for obtaining that review. Pap versus Commonwealth. Citation is omitted. Because the double, so I guess they're just quoting it here. Because the double jeopardy right is a right not to be tried, this court has held that appellate review of the denial of a motion to dismiss on that basis after trial and conviction and would not provide adequate relief if the defendant were to prevail. Flood versus Commonwealth. Citation omitted. See also Abney versus United States. The rights conferred on a criminal accused of the double jeopardy clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. That's interesting. So again, they're like, we got to get this done because if she is convicted, then like this is going to be a whole lot less effective. This court has long recognized that double jeopardy clause protects an individual against more than being subjected to double punishments. It is a guarantee against being twice put to trial for the same offense. All right. Request for oral argument. Ms. Reed respectfully requests that the court hold oral argument on this petition. Introduction. The ancient right to a jury trial is no more procedural formality, but rather a fundamental reservation of power of the American people. Erlanger versus United States. Citation omitted. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the Fifth and Sixth Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons colonists cited in the Declaration of Independence, because again, Massachusetts, the land born of the free, right? Which is so ironic. This entire case and trial is just so ironic that it's taking place in Massachusetts. Our forefathers, man, they'd be rolling in their graves. Prominent among the reasons colonists cited in the Declaration of Independence for their break with Great Britain was the fact Parliament and the Crown had deprived them in many cases of the benefits of trial by jury. Yeah, it was the monarchy, Church of England, all that. Wanted to break free of that. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams, that's a great show, by the way, put it, the founders saw representative government and trial by jury as the heart and lungs of liberty. Oh my gosh. So total side note, one of my favorite shows of all time is Deadwood. And one of my favorite episodes is like in first season where they put together their own government and they have to put together like a trial for Jack McCall for the unaliving Wild Bill Hickok. And it's just like the most ridiculous thing because you look at it and you see like the defense is, oh, well, because I'm alleging, even though there's absolutely no evidence whatsoever, that he unalived my brother in Kansas or whatever, even though he doesn't even know if he has a brother in Kansas. He's like, "Oh yeah, my brother in Kansas. My brother in Kansas. Yeah, he unalived him, so therefore it was a revenge unaliving, and I was justified in that." And it's so wild and so ironic. But anyways, I digress. Follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been that a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Quoting United States versus Martin Linen Supply Company. The double jeopardy clause provides, so they're totally outlining it, provides that no person shall be subject for the same offense to be twice put in jeopardy of their life or limb. Bluford versus Arkansas, which the Commonwealth loves to quote. The underlying idea, one that is one that is deeply ingrained, sorry about that, in at least the Anglo-American system of jurisprudence is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense. Exactly. Innocent until proven guilty, folks. Some people tend to forget. Green versus United States. Even if the first trial is not completed, a second prosecution may be grossly unfair. It increases the financial and emotional burden of the accused, which they outlined, I feel like, in their motion to dismiss as well, too. And some people have speculated on this, is the Commonwealth just essentially trying to drain her of all her wealth, of all her money, to the point where she can't afford to anymore retain AJ or Yannetti, and she has to go with a public defender. I don't know. But I know for a fact that's never going to happen because the more they try and throw something in her way, the more support she gets. So I mean, as AJ said, they ain't got no quit. We ain't got no quit, right? Prolongs the period in which she is stigmatized by an unresolved accusation of wrongdoing and may even enhance the risk an innocent defendant may be convicted. Consequently, as a general rule, the prosecutor is entitled to one and only one opportunity to require an accused to stand trial. Arizona versus Washington. Internal footnotes omitted. See also Martin Linen. At the heart of this policy is a concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Bluford. Clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, and ordeal, and compelling her to live in a continuing state of anxiety and insecurity, which she had said in her 2020 episode is very vehemently expressed, this is no way to live. And she's like, I know that I'm not in jail, and I'm grateful for that. Don't get me wrong, I'm paraphrasing here. But this is also no way to live because you're constantly afraid of, am I going to be going to prison? Am I going to? I mean, potentially for life or for the next several decades of my life, and therefore shortening my lifespan. Especially when she has all these medical conditions, no doubt. It's a lot of stress and anxiety. So I think that's really on point and in line with what she was saying as well, too. As well as enhancing possibility that even though innocent, she may be found guilty, which we see all the time. All the time. Here, the very day after the trial declared a mistrial, counsel for Miss Reed began receiving unsolicited communications from 5 of the 12 deliberating jurors in 4 instances directly from the jurors themselves, indicating in no uncertain terms that the jury had a firm and unwavering 12-0 agreement that she was not guilty of the 2 of the 3 charges, the count 1 and 3, the count 1 being the mega of all mega charges, the M2. Against her, including the charge of M2. Crucially, neither the Commonwealth, which frankly acknowledged receiving communications from one juror, which they did. And remember, folks, the first time they responded to this motion to dismiss was, oh, well, they're just making it up and this is all hearsay and blah, blah, blah. That was literally in their response, their first response to these affidavits. And then you watch the hearing and they're like, well, actually, and they filed like this other response to, or whatever it was, this opposition to their motion to dismiss. And they were like, well, all right, so we did get contacted by these jurors, but we're afraid to dox them. We don't want them to be in fear of harassment, the shock and the horror of potentially doxing them, which is like nobody's doxing them. Like, you can do it in a closed court setting. Like, nobody needs to know their identity or learn anything about what happened in that deliberation room. That's not what we care about. That's not what her team cares about either, or what they were trying to uh extract from that hearing. Crucially, neither the from one juror to the same effect, nor the Superior Court judge who expressly credited the veracity of juror statements relayed in affidavits by counsel disputed the factual basis for the defense motion in any meaningful respect. Yeah, they were like, this is all hearsay. Given the central importance the acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Miss Reed on count 1 and 3 and mandates dismissal of those charges. This presents an issue of first impression for this court, as does the defense's alternative contention that Miss Reed was entitled to a post-verdict inquiry to substantiate her claim, and that this court's precedents permitting such inquiry regarding claims of racial bias should be extended to the present context. Independently, while a jury deadlock constitutes manifest necessity to support a mistrial, there is no authority for the proposition that disagreement as to some counts constitutes manifest necessity for the declaration of a mistrial with respects to all counts. Put another way, there was no deadlock as to the 2 counts. And again, as we saw from the interview, they were both interviews that we covered here on the channel, they had said, yeah, we had come, and I think in the affidavits as well, we had come to a decision on counts 1 and 3 very quickly. That took place over the course of essentially 24 to 48 hours of our deliberating. This is the one that we were hung up, is the manslaughter charge. The trial court's finding that Miss Reed's counsel consented to the mistrial and contrary to both the factual record and the clear binding case law, placing the burden of establishing manifest necessity solely and exclusively on the prosecution. The trial court also failed to address the 2 guiding principles set forth by this court in Taylor, that before a mistrial, so this is really important, folks, before a mistrial is declared, 1, counsel must have been given a full opportunity to be heard, and 2, the trial judge must have given careful consideration to alternatives to a mistrial. So in other words, meaning she was like, okay, mistrial, you've done your service, let's all go home, bring out the dancing lobsters. Like, she had that full on Amanda Bynes moment. And the defense is saying, hey, we didn't have time to consult our client, and let's discuss, let's take a timeout here, process what's going to happen before Beverly Cojones starts bringing in the jury after she decided. And it was like such a whirlwind. And yeah, I know the argument is by the other side. It's like, oh, well, they didn't speak up. Why didn't they speak up? And no one had time to process that fact of, yeah, okay, mistrial, cool, huh? What? And in her filing of her denial, she also stated in that of, well, Mr. Jackson went on, he had no problem going out on the court steps and proclaiming, speaking to the press and the media. And I'm like, what the heck does that have anything to do with what goes on in your courtroom? You have no control over your courtroom, ma'am. You don't. And it's like, just because you don't like Alan Jackson because he's a extremely talented lawyer doesn't mean that you can just do whatever you want because you don't like somebody. That's not how the law works, ma'am. Uh, yeah. Thus, whether the jury acquitted Miss Reed or alternatively was merely not deadlocked on the relevant counts, the Constitution requires the same result: dismissal. The Commonwealth's response on this issue, arguing that inquiry regarding partial verdicts should be prohibited under case law involving lesser included offenses with a single count, unlike the present case. Remember the verdict slips. Raising an important issue regarding the interaction between the lesser included offense case law and mass art crim P27B, which plainly permits and in fact requires the court, before declaring a mistrial, to inquire of a jury whether whether there exist partial verdicts where multiple offenses are charged in separate counts. That was really hard for me to get through. I don't know why. Thank you for bearing with me. Procedural history. On June 9th, 2022, Miss Reed was charged in 3 separate indictments with second-degree unaliving in violation of count 1, manslaughter while operating under the influence of alcohol in violation, count 2, and leaving the scene of collision resulting in death in violation. Yada, yada, yada. A jury trial began on April 16th. I think initially, too, it was set to go for March something, like the month before, or March 12th. And then they pushed it out because Miss Delally was having a hard time providing certain discovery in time. So on June 25th, 2024, the jury began deliberations after receiving instructions from the trial court. The court instructed the jurors, you should continue deliberating until you've reached a final verdict on each charge. June 25th, 2024 also noted that count 2 contained lesser includeds of involuntary manslaughter and motor vehicle homicide, where the jury should consider, even if the Commonwealth failed to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. The following day, on June 26, outside the presence of the jury, counsel of Miss Reed raised an issue regarding the verdict form. With the respect to count 2, the original verdict slip provided only one option: to find Miss Reed not guilty, before going on to ask whether Miss Reed was guilty of the offense charged, or guilty of at least one of the 2 lesser included offenses, which we've also covered here on this channel as well too. See Exhibit B. So that's also included in this Google Drive, which you can skim through as well, and support a motion to amend jury verdict slip. Counsel asked that the form be amended to provide not guilty options for the subordinate charges under count 2. The trial court initially indicated its disagreement with counsel's request, and Bev had a whole hissy fit, and she lashed out on Karen Reed as well, because she was like, this is insane. This is insanity. And she wears her heart on her sleeve. However, after considering the matter further, the court agreed to provide supplemental instructions and amended the verdict slip. But remember that hot mic moment? I did a video on that. Micro Dots did a enhanced audio recording of that they pulled. Somebody had a hot mic. Somebody said something that sounded awfully like Bev, but I don't know. It could have just been a camera crew guy. I don't. It was never confirmed or denied or really talked about after that. But I would be curious. And essentially, what they said is the person on the hot mic. I never changed that. So was it actually changed? I'd be curious, and I would ask that question for sure to the jurors. In fact, maybe if Turtle Boy does another interview, that would be a great question to ask, as well as what did the what did the verdict slip forms look like to you? Can you describe them just so, or like show them like, hey, did they look like these? I don't know if you could do that, but I think that'd be a great question to ask because I would love clarification on, because you saying that you did it is one thing. And, like, did they get the amended copies? The defense, I assume they did, but I would just love to know, is that the final version that they got? The amended ones. The trial court initially indicated its disagreement with counsel's request, however, after considering the matter further, yeah, we just read that. Later that day, the court provided the supplemental instructions telling jurors that count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a vehicle under the influence of liquor. The jury should first focus on that lead charge, and if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. So I'll read that again. The jury should first focus on the lead charge, which is the M2. And if the Commonwealth failed to prove that crime beyond a reasonable doubt, then consider the remaining lesser included offenses in descending order. So count 2 with the lesser included, and then, oh, I'm sorry. Yeah. So lead charge, the manslaughter, and if they didn't find her guilty beyond a reasonable doubt on that main charge, then you can go down the list of order. But the way that they were interpreting it, or how it appears they were, is that they were looking at the whole thing and it's all or nothing. But that's not true, and that's not clear. Clearly, it was not clarified enough. On June 28th, 2024, the jury sent the following note to the court. I'm writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been able to reach a unanimous verdict. June 28th. The court asked counsel for their views on whether there had been due and thorough deliberations. Sufficient support to support the giving of a so-called Tui Rodriguez charge. If a jury, after due and thorough deliberation, returns to court without having agreed on a verdict, the Commonwealth responded that the charge should not have been given because there simply hadn't been sufficient time yet. And this is what the Commonwealth essentially argued is, hey, the defense was okay in all 4 of the Tui Rodriguez instruction to be read after the first note of them saying we're at an impasse. And the Commonwealth was the one that said, hey, let's encourage them to deliberate further. And that is essentially what they argued is like, hey, if you really cared about it, then why did you speak up? Why were you all for the mistrial originally? So, which is a dumb argument because it's like it could be a strategic decision to not speak up, right? You want to do the best thing, and sometimes it's hard. Sometimes that's hard to know exactly in the moment, right? The trial court sided with the Commonwealth ruling. I am not prepared to find that there have been due and thorough deliberations at this point, so I'm going to send them back out. This was the other note that they sent on July 1st. So this was the last day, right? The last day when they declared a mistrial. Spider commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implication it holds. July 1st, upon being asked by the court, the parties reiterated their same previously expressed views. Commonwealth taking the position that due and thorough deliberations had not yet occurred, and Miss Reed's counsel arguing that the court should give a two-way Rodriguez instruction. This time, the trial court decided to give the requested instruction. So again, the Commonwealth was like, no, keep them in there a little longer, and Bev was like, I can't do that again. Later that day, the jury sent another note, or excuse me, yeah, cool. So they gave the instruction, they go back in, and then the jury sent another note. Therefore, without reading the note to counsel and without providing with either an opportunity to be heard or an opportunity to consult with their client about the implication of a potential mistrial on one or more charges, the trial court simply stated the jury is at an impasse and called in the jurors. So exactly, and that's pretty much how it went down. Is jurors send in a note. She says, call in the jurors. And then she's like, I'm going to declare a mistrial. And then they're like, well, all right. Okay. It then read the note on record. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet the standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to lack of effort or diligence, but rather sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Just gonna take a sip of water. So yeah, essentially, and now that we've seen these juror interviews, I'm feeling less and less like, oh, but did you do due diligence? Because allegedly, from what some of these jurors are saying, some people had already made it up in their minds that she was guilty and didn't want to deliberate. They wanted to go home, be over with it, yada, yada, which is terrifying. And I hope that nobody in this community ever has to go through that, because that's terrifying. Your life is literally in the hands of strangers. And the fact that some people were like, yeah, she's guilty because. Why? Just because. I don't like how she looks. Like you don't want to at least review the evidence? Don't you think you owe it to yourself after all that week of just sitting there? But again, this is just what's been reported, so I don't know. But if that is the case, I mean, that's terrifying, right? After reading the note, without soliciting the views of counsel in any respect, the trial court stated, I am not going to do that to you folks. Your service is complete. And she takes off her glasses. The service is complete. I'm declaring a mistrial in this case. And everybody's like, all right. The jury was then excused and ordered to leave the courtroom. Counsel was not invited to speak during this interaction. Following day, on July 2nd, unsolicited by any party, one of the jurors contacted one of the attorneys for Miss Reed, Alan Jackson. Juror A stated that he or she wished to inform AJ of the true results of the jurors' deliberations. They attached the affidavit. According to Juror A, the jury unanimously agreed that Karen Reed is not guilty of count 1, M2, and was empathetic that count 1, M2 was off the table, and that all 12 jurors were in agreement that she was not guilty of such a crime. And yeah, I can't imagine the burden and the weight you would feel of like, this poor woman might have to go through this again. And what if she gets convicted when we decided unanimously that she wasn't? The jury also unanimously agreed that Karen Reed is not guilty on count 3, leaving the scene with injury or death. One day later, July 3, and again, this is like the week of the affidavits just dropping every day, and everybody on Twitter is like clutching their imaginary pearls like, oh my God, what else is getting dropped today? Another attorney for Miss Reed, David Yannetti, was contacted by two different individuals, the informant B, the informant C, who had received information from two distinct jurors. They had the screenshots, they had the receipts, both of whom were part of the deliberating jury in this case. So we have videos on all that. I'm not going to go back to those affidavits. You can check them out in some of my videos on my channel. Just check out the Karen Reed playlist, and you can find all those videos there. There's a lot. Informant B sent Yannetti a screenshot he or she received from intermediary B. So again, that's like, I heard it from a friend who got it from my friend. Text messages, but it's screenshots, it's evidence, it's receipts. That's why it's important you call in the jurors, right? Bring the jury. That intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second degree charge. I thought the prosecution didn't prove the case. I mean, we didn't either. No one thought she hit him on purpose or even thought she hit him on purpose. Juror B later placed an unsolicited phone call to Yannetti. So this juror who hadn't contacted him initially, this was a friend of a friend who did, confirming that the information contained in the publicly filed affidavit was accurate. So they saw it. It was posted everywhere on the interwebs, and they're like, yeah, that's true. I wasn't going to come forward because they were probably scared. But they were like, yeah, that's true. I'm going to do the right thing. And they did. And kudos to you. You got the real cojones. Juror B clarified, however, that he or she meant to write. No one thought she hit him on purpose. So this is the clarification from that sentence because we all read that and we're like, huh? No one thought she hit him on purpose or even knew that she had hit him. Juror B further told Yannetti that he or she believed that every member of the jury, if asked, would confirm that the jury reached non-guilty verdicts on indictments 1 and 3. So they were essentially saying on behalf of the group that, hey, I'm fairly certain that if you asked all 12 or they came forward, they would agree. They wouldn't lie about it. So, and that's a bold statement. So then they include this, which we've read 1,000,000,007 times. So I'm probably going to zoom past that. But informant C had been in contact with another individual, intermediary C, another friend of a friend who is a coworker and friend of juror C, and joined a Zoom meeting during which juror C discussed the trial. So probably on like a work meeting, and everybody's like, tell us more about it. Give us the tea. Informant C sent Yannetti the below screenshots of his or her text messages regarding what juror C revealed in the Zoom meeting. So I wonder if I guess these were like, while the meeting is going on, somebody like private DM'd them, because you can do that in Zoom if you guys aren't familiar. And they were like, hey, so like, what was it like? While like their boss is probably doing some boring, useless meeting that could have been an email anyways, but whatever. So this, you can read this again. I'll share it. It's also in the affidavits. Miss Reed moved to dismiss. I think this is the one too where they were also like, we were intimidated by Brian Albert. I think this was the same, but yeah, they had said no consideration for M2. Manslaughter started pulling on at 6-6, then ended deadlock at 4-0, 8 yes. So it's reported a ton. Lots of people are like, it was 9-3, but it ended up being 8-4 because some people flip back and forth. Miss Reed moved to dismiss counts 1 and 3 on double jeopardy grounds, contending 1, that the jury reached a final unanimous decision to acquit her on those charges, and 2, that there was no manifest necessity supporting the mistrial given the evidence that the jury was not deadlocked, but instead was in agreement on those counts. In the ensuing days after filing Miss Reed's initial motion to dismiss, but before the Superior Court hearing on that motion, Attorney Jackson was contacted by 2 other deliberating jurors. And again, a mic drop, another mixtape drop. The first juror, D, stated that the jury reached not guilty verdicts on count 1 and 3, which again is all they want to know. They just want to interview. They just want to speak to these people, and they only need to ask this freaking question. Did you vote not guilty on counts 1 and 2? Counts 1 and 3. Cool. Nice. Have a great rest of your life. The disagreement was solely on count 2 and its lesser offenses. Supplemental affidavit, she recounted that, or she recounted after the jury was excused and aboard the bus, many of the jurors appeared uncomfortable with how things ended, wondering, is anybody going to know that we acquitted her on count 1 and 3? Juror D unequivocally told counsel, every one of us will agree and acknowledge that we found Karen Reed not guilty on counts 1 and 3 because that's what happened. Then Juror E similarly stated that the jury was unanimous on count 1 and 3 and that Karen Reed was not guilty of those charges. So see this affidavit by AJJ. I just real Alan J. Alan J. Jackson, AJJ. Everybody calls him AJ, but he's really AJJ. The Commonwealth filed a post-trial notice. So this is where it gets great, guys. Of disclosure, informing the court that on Sunday, July 21st, ADA Lollipop Lally received an unsolicited voicemail on his office's phone line from an individual who identified themselves as a juror by full name and seat number. See this. The message stated, it is true what has come out recently about the jury being unanimous on charges 1 and 3. And like, that's the thing. It's like they didn't just contact the defense, they contacted the DA's office. So how are you going to get around that, bro? How are you going to do that? ADA Lally received a subsequent message from the same individual stating that he could confirm unanimous charges on 1 and 3 as not guilty, and as of last vote 9-3 guilty on manslaughter charges. Commonwealth additionally, so this was, again, it's reported all different kinds of number, but it was 8-4 at the end. Commonwealth additionally received emails from 3 individuals who identify themselves as jurors and indicated they wished to speak anonymously. So 3 other people contacted the DEA's office. So no, it's not bias, it's not hearsay, because you're getting the dang same messages, bro. Commonwealth declined to substantively respond to the voice messages or emails, instead claiming in responsive emails that it was ethically prohibited from discussing such matters. Yeah, only if you hit them up first. But if they hit you up first and they slide into your DMs, bro, guess what? You can say, hey, we got this too. And then you can request from the court, just like the defense did, and say, hey, can we interview these jurors? Because we're, in the business of seeking justice and all, right? That's the business that we're in. Not in Norfolk County. Deny, 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 deny. After hearing oral argument on August 9th, on August 23rd, the court issued, so they had on August 20th, what was that one? Was that the motion to dismiss that one? Yeah, one of them was like, hey, this was the hearing. Where they were like, let's set a date. Let's set a date to set a date for a hearing. Like, it's so dumb. The court accepted for the purposes, one of those, like, it could have been an email bev, like, hello. The court accepted for the purposes of the motion to dismiss that the juror statements quoted in the defense affidavits were true and accurate. It went on to hold, however, that because there was no open and public verdict affirmed in open court rendered in this case, the defendant was not acquitted of any of these charges. This is what Bev said. The court similarly rejected the defense argument lacking of manifest necessity, finding that Karen Reed's counsel consented to a mistrial via their failure to object, which is like the don't ask, don't tell thing. Like, it's the same thing. Well, if you didn't say no, or like the whole, like, oh, in order to say that you're consenting to something, you have to verbally say no. Like, this is like I want to say the 1920s, but really, like, let's be real. This is even in today's world where you're talking about things about consent. It's like, oh, if you didn't scream no and you didn't struggle, then you couldn't have possibly been a victim of blankety blank. It's the same thing. And it's dumb. It's so dim. It's so dim. And we're in a new era. Cajones. Court similarly rejected the defense. Yep, we just read this. And B, the jury notes, reflecting an impasse established the requisite of manifest necessity. Yeah, so she's saying, well, they said they were at an impasse, so it must have been of everything. But you didn't ask, Bev. You didn't say, hey, like, do you mean of everything? Like, how hard is it for you to just ask a question? It's really not that hard. Or are you too afraid? You're afraid to drag this out even more? Because I feel like, well, actually, no, if you get a verdict, then that means no more court TV for you. So, I don't know. I think, honestly, Bev, this is my speculation with Bev. I think Bev was hoping for a mistrial. Maybe because of she likes TV, she likes the camera, she likes, being Beverly, the Honorable Judge Beverly Canoni, and it being her courtroom, right? But that's just my opinion. That's just my unless she really knows that Karen Reed is innocent and she's just like playing. I don't know. I don't know. She's playing it out for the camera. The court did not address the Taylor test for declaring a mistrial based on manifest necessity, nor did it address Miss Reed's contention that the burden of demonstrating manifest necessity squarely on the prosecutor. The court instead erroneously uh, equated a request for Tui Rodriguez instruction, which is designed to encourage a verdict with consent, to a mistrial. So she's saying, but it's implied. It's implied consent, which is just, ugh. It's like saying, like, you go home with somebody, right? Like, you meet them at the bar, you go home with them. Because you went home with them, therefore that means, right? Like, okay, cool, let's take it to the bedroom. No, that's not what that means. That's not what that means. That's not what consent means. Finally, the court rejected the defense's alternative request for a post-trial inquiry on these issues on the grounds that the request implicated the substance of the jury's deliberations. Miss Reed's retrial is currently scheduled in the beginning to begin January 27th, 2025. So memorandum of law. So yeah, now they're gonna get into all of it. So this is the Turtle Boy footnote. I want to read this out, and then I'm probably gonna call it because there's so much. There's so much in this. They quote Murdaugh. We'll see. We'll see what happens. The jury's unanimous conclusion following trial that Miss Reed is not guilty on counts 1 and 3 and constitutes an acquittal and precludes re-prosecution. Constitutes an acquittal is not to be controlled by the form of the action in question. Quoting Martinez versus Illinois, rather, the court must determine whether the action actually represents a resolution, correct or not, of some or all factual elements of the offense's charge. Commonwealth versus Babb. The mere presence or absence of check marks on a form is not dispositive. Taylor. Here, the affidavits by attorneys Alan Jackson, AJJ, and Yannetti reflect statements by 5 deliberating jurors that the jury had reached a final unanimous conclusion that Miss Reed is not guilty of counts 1 and 3. There was nothing tentative about the jury's statements. To the contrary, they were definitive in describing the results of the jury's deliberations. See affidavit AJJ. Juror A was emphatic that count 1, M2 was off the table and that all 12 of the jurors were in agreement that she was not guilty. Affidavit of David R. Iannetti, reflecting text messages from juror B. It was not guilty on second degree. No one thought she hit him on purpose or even knew that she had hit him. reflecting Juror C's statement relayed by intermediary C that there was no consideration for M2 and Miss Reed should have been acquitted on that count. Supplemental affidavit of AJJ. Juror D, without hesitation, and said in substance, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. And I feel like that should just be the slogan, ... because that's what happened. The second supplemental affidavit of AJJ, Juror E, explained that the jury was unanimous on counts 1 and 3 and that Karen Reed was not guilty of these charges. As noted above, the trial court accepted the foregoing averments as true facts. What does that mean? My vocabulary, man. An assertion or affirmation of fact, especially a positive declaration of allegation in legal pleading. Okay, so I could have just read this like first little part. An assertion or affirmation of fact. Got it. I understand that. Thank you. This is why this is not meant to be read by people like me, where we have to look up definitions of things because I'm like, there. In rejecting Miss Reed's claim of acquittal, the court relied solely upon the lack of open public verdict affirmed in open court. This reasoning is rooted in a formalism that has been consistently rejected by the U.S. Supreme Court and Supreme Judicial Court in a string of precedents spanning more than 100 years. Ball versus the U.S. However, it may be in England, in this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. Hudson versus Louisiana, holding that judicial grant of new trial prohibited retrial of double jeopardy grounds, notwithstanding that the state code of criminal procedure did not authorize trial judges to enter judgments of acquittal in jury trials. So, from my understanding, they're saying when it is in regards of double jeopardy, it's not up to Bevity Bev to make that decision of acquittal. So there we have it. Which I everybody's like pissed, like, oh, why didn't she dismiss the charges? One, that's what we all expected. But two, I also think she's like, I want this out of my hands. I want to catch my tan, eat my lobsters, do my thing, my hot girl summer, do all that. But yeah, I don't think she wanted to deal with this. I think she's like, yeah, fine. I'll just make things easy for everybody and just give the DA what he wants, like do all that, whatever, you guys figure it out. You duke it out with the SJC. Indeed, under the trial court's reasonings, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. Surely that cannot be the law. Indeed, it must not be the law. Let's read that up. Read that back. Back it up. Indeed, under the trial court's reasoning, affidavits executed by all 12 jurors attesting to a final unanimous decision to acquit would not be sufficient to mount a successful double jeopardy challenge. So they're saying, yeah, like this can't be double jeopardy because if they all say they acquitted her, then that's double jeopardy. It is what it is. You cannot commit. If the glove doesn't fit, you cannot acquit. If the taillight pieces don't reveal themselves and they're planted, then it doesn't have the same ring to it. Surely that cannot be the law. Indeed, it must not be the law. And in the context of this highly publicized case, it's strange credulity, which is so interesting because Melanie Little says that all the time, and you know that they're watching her channel because she's awesome. To suggest that if the unequivocal statements of 5 jurors quoted above did not, in fact, represent the unanimous view of all 12 of the remaining jurors, would allow the inaccuracy to go uncorrected. Instead, they would, and let's read the footnote. Well, this is the same footnote that actually we read, but this is the Turtle Boy quote saying, yeah, it was very clear that and it's a great use of that of that source, I gotta say. That's great. Instead, they would predictably have notified the Commonwealth or the court of their own recollection. Here, to the contrary, the Commonwealth has received the exact same information as the defense regarding the jury's unanimous agreement to acquit Miss Reed on counts 1 and 3. Yeah, it wasn't just us. And I think that's why this makes this even more strong, right? Even stronger. The U.S. Supreme Court's decision in Bluford is not to the contrary, as it is factually distinguishable from the instant case. There, the foreperson had reported during deliberations that the jury was unanimous against the charges of capital M and first degree M, but split on manslaughter. The court sent the jury back to continue deliberations when the jury remained unable to reach a verdict, declared a mistrial. SJC. The Supreme Court rejected the defendant's argument that double jeopardy clause prohibited reprosecution for capital and first degree M. In doing so, the court relied heavily upon the lack of finality of the juror's report. The jury's deliberations had not yet concluded, and it went back to the jury room to deliberate further. The foreperson's report was not a final resolution of anything. There was no indication at the conclusion of deliberations that it was still the case that all 12 jurors believed the defendant was not guilty of capital or M1. Here, by contrast, the jurors' statements reflect a final and indelible determination that persisted throughout the end of deliberations and followings. And I think this is a really interesting use of this specific case law, because this is the one I believe that the Commonwealth loves to use, right? They're like, see, though. But then the defense is like, well, here it's like the opposite, because they were final on it. So it's completely contradictory to this case law, because they did have a final verdict on these things, and therefore it should apply, right? There would be double jeopardy. The contrast with juvenile versus Commonwealth is even clearer. And this is, again, the same one I think that the Commonwealth has used in their arguments and filings. In that case, after the conclusion of the trial, court officer found 4 verdict slips in the deliberation room, 2 of which reflected entries of not guilty. There was no indication as to when the entries were made or in what circumstances, much less they reflected a final unanimous conclusion of all jurors. Neither the Commonwealth nor the trial court has cited any case in which a defendant was forced to stand trial a second time for an offense a previous jury had found her not guilty of, simply because such final unanimous agreement was not announced in open court. Counsel arguing that Commonwealth had not cited a single case with facts like this that have been ignored. Not a single precedent have they raised nationwide, state courts, M cases, 50 states, federal, where that's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. See footnote. Other cases cited by the trial court on this issue did not involve double jeopardy challenges at all. See Commonwealth Zacharias, Commonwealth versus Floyd. In these cases, both vacated convictions where courts responded to ambiguous communications by jurors in such a way to improperly influence the return of guilty verdicts. Ooh, scandalous. Given the gravity of criminal conviction, it makes sense to insist observance of procedural formalities before taking away a defendant's liberty. Yeah, because life, liberty, or death, man. That's what our forefathers fought for, right? However, in light of the fundamental constitutional prohibition of double jeopardy, refusing to give effect to a verdict of acquittal due to the lack of formality in another matter altogether for which neither the Commonwealth nor the trial court has cited any precedent. Additionally, unlike in Zacharias and Floyd, there is nothing ambiguous or tentative about the post-trial evidence of verdicts here. And I love how they're calling it out and they're breaking everything down bit by bit. So I am curious. I think this probably was written by the new attorney, since that's his thing. The instant case squarely presents that issue, and the defense respectfully submits that this court should hold that any lack of formality does not supersede the defendant's fundamental constitutional protections. This issue is one of existential importance, not merely to Miss Reed, but to the very foundation of the constitutional safeguards that protect her. And again, that's the big issue. This is the big stink that everybody says we have. All the free Karen Reed freaks that they like to call us, right? We are standing up for it's not just about Karen Reed, right? It's not even just about, and it's sad. It's sad because justice means for John O'Keefe, justice for Karen Reed. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. The law is clear that, at least in the context of juror bias, an affidavit by counsel is sufficient to entitle the defendant to a post-verdict inquiry on the issue. And again, that's all they want. They just want to ask. They want to ask one question, one stinking question. No less than the right to an unbiased jury. It is a fundamental tenet of our system of justice that a defendant may not be tried for a crime of which she is previously acquitted by a jury, and the defense submits the post-verdict inquiry is equally warranted in the present context. We're almost done, folks. Other than generally noting that this case does not involve an allegation of juror bias, I don't know. According to those interviews, I don't know. The trial court did nothing to distinguish McCallop. But there is no apparent reason to limit a defendant's entitlement to a post-trial inquiry to the same issue of racial bias alone. Recently, the U.S. versus Sarniev, the First Circuit Court of Appeals remanded the matter for further proceedings in the Boston Marathon case due to two jurors posting on social media regarding the case and the district court proceedings, which came to light after the jurors had been provisionally selected to serve. The comments did not reflect the racial bias in any way, but rather possible bias specific to the defendant. The comments were also inconsistent with the jurors' assurances that they had not discussed the case online. First Circuit Court, which is like that is a crazy case in itself too. I might actually cover that one time because it's just like deeply fascinating. First Circuit held that district court erred by failing to inquire about these issues with the jurors, given that the right to an impartial jury is a constitutional bedrock. When there is plausible claim that a prospective juror lied in a manner that may reveal bias, a court need conduct some inquiry reasonably calculated to determine whether the prospective juror did lie, and if so, why. This is what we saw too in the Ashley Benefield case, right? Where one of those jurors, and this is a reason why she might get a retrial, is because, or her defense is going to argue for a retrial, because one of the jurors lied about their history of DV, of not only being a survivor of DV, but being an alleged perpetrator as well too of DV. So, and they flat out lied, and they were on the jury. Then there was allegedly another juror whose brother or relative was in the long crime chat or court TV chat and was giving live updates of what was going on inside the jury deliberation pool, which I don't know if there's any validity to that or not. But I mean, if those claims are true and she snuck in a flip phone somehow into a jury deliberation room, I mean, that is insane. That is cocoa bananas. And would mean that she has a right for a retrial. Again, totally different situation, but in regards to this specific case law, jurors lie. Jurors lie. And here, there are potential issues of juror misconduct, with that one juror talking to their family members about Turtle Boy. And why it's such a big deal is because Bev permitted the whole witness intimidation talk into the trial from the McCabe daughter, Allie McCabe, right? Crucially, for present purposes, the First Circuit ordered the district court to voir dire the jurors. In doing so, the court acknowledged no doubt any juror would have some strong incentives to avoid admitting having committed perjury during their voir dire. We also expected that most jurors have taken the time out of their daily lives to receive evidence at trial, deliberate with other jurors, and reach a verdict that they believe is just, would prefer not to have the verdict disturbed, especially as a result of their own actions. So essentially saying, I don't want to revisit this. We have no doubt that the able district court judge can do what judges regularly do: form a considered opinion about the sufficiency of juror explanations once those explanations are given and explored. Another high profile case is South Carolina. Yeah, so this is about Murdaugh. That during his trial, the clerk of court improperly influenced deliberating jurors. See State versus Murdaugh, which is wild. Like, who put that on your bingo card, right? Jurors came forward after the clerk published a book about the trial describing her efforts to, which is wild, efforts to obtain a guilty verdict through improper jury tampering. Like, what a clown. I didn't follow this case too closely. Like, I followed some of the investigation and stuff like that, but not the trial. But I did hear about this. I'm like, holy smokes. Emily D. Baker did gavel to gavel coverage of this trial. So definitely go check her out if you aren't following her already. Brief of appellate attached here, Exhibit B at 2. Clerk allegedly told jurors after the defense began its case not to let the defense throw you all off or distract you or mislead you, and warn them not to be fooled by Mr. Murdaugh's testimony in his own defense. Now he might get a retrial, which is like wacko. The trial court held an evidentiary hearing on the motion for a new trial, including testimony by jurors. As in Sarniev, the issue was not racial bias, but nonetheless implicated fundamental constitutional rights, like Miss Reed's right to not be retried for offenses of which she has already been acquitted. Trial judge dismissed Miss Reed's reliance upon Sarniev and Murdaugh in a brief footnote because they quoted that in their motion to dismiss, simply stating that the circumstances are readily distinguishable from those at issue here. Order at 21, but this misses the forest for the trees, and I love this because she said shrinking violets in her. So I like that they're using the forestry, the forestation. I like the imagery. While it is certainly true that all three cases raise different issues, the fundamental point remains the same. A defendant who comes forward with credible evidence of a serious constitutional violation post-trial, is entitled to an opportunity to prove those claims. There is no apparent reason to artificially limit the availability of such constitutional inquiry to the singular context of racial bias. The defense request does not in any manner infringe upon the substance of the jury's deliberations. Yeah, so again, they're reiterating, we don't care what happened in the room. And that might change, but we just want to know yay or nay. To the contrary, the motion to dismiss was predicated solely upon the result of deliberations, namely a unanimous decision that Ms. Reed is not guilty of M in the second degree. Relevant inquiry could be accomplished by a single yes or no question. Yes. To unanimously acquit Karen Reed of these charges in counts 1 and 3. Of course, the results of a jury's deliberations are not secret. No, because it's like either you get a verdict or you don't, and it's a mistrial. So why is it a secret? They are, in fact, routinely announced in open court. Here, the defense has learned post-trial that the jury reached a verdict that was not announced, or not so announced. It was at least entitled to the opportunity to substantiate the fact in order to ensure Ms. Reed is not unconstitutionally forced to stand trial for criminal offenses of which she has already been acquitted. Such inquiry in no way intrudes on the deliberative process of the jury. Indeed, it was the trial court, not the defense, that injected issues regarding jury deliberations into the inquiry. It is simply not true that given the content of the jury's final note to the court, Any inquiry would necessarily require the court to understand why the jury's final note communicated a deadlock on charges when post-trial certain deliberating jurors are purportedly stating that the jury was in fact unanimous on most of the charges. As explained in infra pages 28 to 29, in light of the trial court's instructions repeatedly characterizing the lesser included offenses within count two, as discrete charges, the jury's note is readily susceptible to interpretation consistent with the post-trial evidence supporting the defense's motion. Footnote: This distinguishes the case from a juvenile where the jury foreman had expressly indicated that the jurors were deadlocked on the complaint which charged unaliving. And the jurors subsequently reaffirmed the fact in open court. I see what you did there, AJJ. Actually, not just AJJ. I see what you did there. Pabian. It's like Fabian, but Pabian. In these circumstances, a post-trial subpoena to the foreman regarding verdict slips recovered from the deliberation room after the trial, that very count could only be aimed at impermissible impeachment months after the fact of the jury's report to the judge in open court. So essentially, they're saying, yeah, but they said that in open court. Hereby contrast, no statement or inquiry was made regarding whether the impasse was related to any specific counts. Jury note expressly stated that the jury cannot reach a unanimous verdict as to either of the two indictments. In any event, the jurors state that they acquitted Miss Reed. No further inquiry regarding contents of the jury note could possibly remove the clear constitutional implications of such acquittal. So this is where I'm going to call it for now, folks, because we still got like another like 17 or so. Do we? Wait, hold on. Yeah, we still got like another like 10 pages. Sorry. And it's getting late, and the wife needs to get up early and use the bedroom. So I'm going to link this and we can finish our readout of this in our next video. But we really hit on the main points, anyways. I mean, the biggest points were kind of rebutting some of the case law that was used in the Commonwealth's motion or the Commonwealth's oppositions and their arguments during the motion to dismiss hearing. And I think that was really smartly used. I like how they use the Murdoch case law as well too with Becky Hill. I liked how they used the Turtle Boy article to really highlight that, hey, jurors are coming forward and they're going to keep talking to the press. The more that you ignore them and you try to silence them, they are going to start talking, and maybe we'll even hear from some of the guilty voters as well too. Who knows? I mean, I feel like those are probably the ones that are the most, I guess, hesitant to come forward, and that's fine. They have every right to stay anonymous. They don't have to speak up, and nobody should be pressuring them to speak up. But at the very least, the defense deserves a stab at interviewing these jurors and getting a chance to find the truth, because it feels like the defense is the only one who wants the truth, right? It feels like they're the only ones really fighting for truth, really fighting for justice for John O'Keefe, and really fighting for free Karen Reed. And with that being said, if you like today's video, make sure you hit that subscribe button. Make sure you hit the notification bell so you don't miss the next Karen Reed update from me, where we'll continue on with this readout. Make sure you hit that like button because it tells the YouTube algorithm that this is newsworthy news. And remember, the more people we reach, the more pressure we put on the DA's office to do the right thing. And at the very least, the bare freaking minimum, Morrissey, is just drop the count 1 and 3 charges. I mean, save yourself, bro. Like, really, because the more and more you just hold on and you hang tight and you fight what you think is the good fight, the more and more people are going to do digging and exposing. And there's a whole lot of crap too that we haven't even talked about. There's some people that he is connected to who have been charged with some pretty heinous crimes that we might even talk about here on this channel too, because the corruption doesn't stop right here. It goes much deeper, and it even goes up to the governor of Massachusetts, Governor Haley, as well too, his buddy. So that being said, I will see you in the next video.